Hi, this is Wendy from the HMO Action Group. I thought I would do an update for you on what's been going on behind the scenes with the HMO Action Group. As you know, we are working very hard to make people aware of the problems with the Renters' Rights Bill. Particularly, we want to focus on HMOs, and we're thinking not just of landlords, we're also thinking about tenants, because these are the two parties that make up a successful HMO, as you will know. Now, there are some wins which we'd like to share with you, that we're very excited to share with you. For example, having lobbied a number of MPs that are on the Housing Committee and on some of the subcommittees that have worked for the bill and have set amendments into the bill, and these are cross-party MPs. Did you know that there are now 44 mentions of HMOs in the Renters' Rights Bill, as opposed to 2 when it was first written? So we know that our voice, the letters that you've been sending, the emails, the contact, the phone calls, the webinars, the Zooms that we've been holding with MPs have definitely raised the profile of HMOs in the Renters' Rights Bill, which is really good news. So that's something we can celebrate. But we still have some major concerns, as you know, about the Renters' Rights Bill. So some of those concerns focus on the 3 key areas that we have been lobbying for over the last 6 months. We're still very concerned about students, and I'll come on to that in a moment. We're still very concerned about implementation, and we're still very concerned about antisocial behaviour. Now, some news on antisocial behaviour first. Now, what's, again, been edited and has changed a little bit in the Renters' Rights Bill since it was first introduced is that there are 2 types of Section 8 eviction process. There's the mandatory process, which basically means if you can prove it's happened, we'll give you a possession order. And then there is the discretionary process, which is that you would have to, I suppose, take your evidence to a judge, debate it with the judge, and the judge can decide whether or not to give you a possession order based on the evidence you provide and the balance of likelihood that you're correct and that the tenant isn't. Now, antisocial behaviour under mandatory grounds only refers to serious antisocial behaviour. So if a tenant has a conviction or an ASBO. So obviously, if you're going to have to wait for a tenant to get a conviction for antisocial behaviour or to get an ASBO, that is going to take quite a lot of time. Having said that, you can serve that immediately. Immediately that you know that that's the case, you can serve it and you can escalate it straight away. On the discretionary grounds, domestic abuse is part of that, damage to furniture, damage to property, and I suppose you could call it sort of unconvicted or sort of informal antisocial behaviour. Again, that period is immediate, but you still are going to have to prove it in order to get the possession order. So I could still see a lot of problems in the courts when Renters' Rights Bill comes in, because all of these challenges, all of these reasons that you might want to use to get rid of a tenant, you're still going to have to go to the court to get that possession order. Even though some of them are mandatory and some of them are discretionary, without that bit of paper that says possession order across the top, you haven't really got legal possession of that room or that property. So it's still going to be very problematic, and how the courts are going to cope with the influx of Section 8 hearings that are going to happen as a result of it, well, I can just see lots of jobs, for magistrates and judges coming up. So if you've got any kind of legal training, you're going to be in the right place for that. Now, student HMOs, that was the second one on my list. So student HMOs are still very problematic. The government have introduced a Section 4A, which is quite tortuous. Basically, if you're a student landlord and you want to get your property back before the start of the new academic year, you will be able to give notice to your students, but number 1, that notice period has to be 4 months. Number 2, the notice period needs to take effect between the 1st of June and the 30th of September, if you like, of the following year. And number 3, that tenancy must not have been entered into prior to 6 months before the tenancy started. In other words, if, like most student landlords, you start your tenancy agreements, let's say in January, or you get the tenants to sign up in January, which is more than 6 months before the start, before when they maybe move in September, you won't be able to use Section 4A. So the start date of that tenancy now becomes very, very important, whereas in the past, it's been irrelevant. Students will be signing on to a joint and several liability periodic tenancy. What does that mean? Well, that means that now if one of the students in that group of students gives notice to quit, the whole tenancy is now null and void. The whole tenancy falls apart, which means that you could still have 3 or 4 tenants, let's say in your 5-bed HMO, and they might decide to carry on living there, but you will have to issue a new tenancy agreement. And they are now no longer required to be severally liable for the 5th tenant, because once that 5th tenant has given notice, remember they only have to give 2 months notice to leave. So they could give in their notice in January, leave in March, and then you as a student landlord, what are you going to do between March and say September? That room's going to remain empty. I can see an exodus of student landlords leaving the market, and we're going to see lots more HMOs coming onto the professional market as well. And that in itself is going to be a bit of an earth-shattering event potentially, particularly in student towns and cities. So I can see some creative options being exercised here. I could see lots of things that student landlords might decide to do to try and avoid some of these problems. And I'm not going to outline here what I think some of those solutions might be. You can contact me independently and I will tell you what I think those might be. But I do think that students are going to suffer a little bit under the bill, because it's very likely that the costs of their accommodation are going to go up. Many of them may decide to move more into the PBSA, private built student accommodation sector, where rents are typically higher, but they have, of course, far fewer rights. And where the term, because it's often more on a serviced accommodation type agreement, those agreements are, they can be ended at any time by the university, who often owns the PBSA, or by the private owner of that PBSA unit. I think landlords in the student sector are probably really bracing themselves for the changes that are going to happen, and may well be thinking right now that this is their last year in that sector, which is very, very sad, when for many students it's a great form of accommodation and they really enjoy living together with some of their friends in a shared house. Certainly my sons did when they were at university. They all lived in shared houses and had a whale of a time. I must admit I never did, because after 1 year of living in halls, I then bought my own property and moved out. But for a lot of people, a lot of students, this is a standard way in which they live, and for a lot of student landlords, of course, it's a great way for them to make an income and to serve their local population. Now, the third issue that, of course, we've mentioned is implementation. What really worries me the most about this bill is that it is due to be implemented on the day that it receives royal assent. Now, if that happens, it is going to cause absolute mayhem across the sector. The number of landlords, agents, software companies, businesses that are going to be impacted by this. Never before have we ever seen a sledgehammer so hard and forcibly pressed down upon the market, and in such a sudden manner. This is a bit like deciding overnight to change a contract, let's say your mortgage contract, or your car lease agreement, or some other fundamental rule of law. Overnight is going to change. Your tenancy agreements will no longer be ASTs, they will be periodic from that very, very date. Implementation is shocking, it's going to be sudden, and it's going to be worrying. And this is what worries me most actually about this bill, is everything that's going to have to change on that one day and the impacts that that's going to cause and create. No longer will people be able to pay upfront for their, for 6 months or a year. Again, this will have a big impact on the student sector as well, because you won't be able to pay your rent in advance. And there have been lots of discussions about that. How will students manage with their student their student rent, with the student loan that comes 3 times a year? They're now going to have to learn to budget. Well, that's probably no bad thing, actually. Maybe there's a bit of a life lesson here. But nevertheless, it's going to potentially, I think, cause some difficulties. And some guarantors are going to be phoned up to say, I'm sorry, I've run out of my rent. Please, can you make up for it? So if you're a guarantor, watch out. But yeah, this is all to do with the fact that implementation is going to happen on day one. And so you better be ready, because this is going to happen sooner than we think. It's going to be sudden. It's going to be like an overnight earthquake. So be ready for it. But what I'd like to tell you on the good side of the coin is that as the HMO Action Group, we are well aware of these challenges. We are in the process of writing to the House of Lords as it goes through the Lords and is debated. And I am very hopeful that we will see further amendments to the bill as the Lords stand back, analyse it and decide that some of this is just not workable. And those Lords that are heavily invested in the property sector, I am very hopeful that some of them have seen sense and will be arguing against this bill. That will mean 2 things. Number 1, there will be further amendments written into the bill. But number 2, there may well be a delay on its implementation. And that can be nothing but a good thing to help us in the private rental sector adapt to it and prepare for it. And also for tenants to adapt and prepare and be ready for it. But also so that the Commons and the Labour Party recognises that implementation overnight is a very, very bad idea, and it should be in a staged, gradual process to allow us to adjust to this very, very sudden alteration of what has become fundamental to the private rental sector for the last 40 years.